Just a moment. So we are officially live. Um, I think the sound is working. Okay. Good evening, everybody. Just to introduce you again, my name is Frank Sawicki. I am the programs manager here at Family Promise of Sussex County. And welcome to another evening of STEPP. This is Stabilizing Tenancy Eviction Prevention Program. So this has been a really wonderful opportunity for Family Promise of Sussex County to present landlord-tenant law matters to the community. So just to give you a brief little rundown, again, my name is Frank. I work here at Family Promise. I've been here for a little while, probably close to 2 years now. And what we've been doing is we worked with the New Jersey State Bar Foundation. So we reached out to them. They had applications available to apply for grants and programs. And one of their grant opportunities allowed us to establish this program where we reach out to area professionals. I'm going to introduce our guest shortly. So one of the things we do is we reach out to area practitioners, service providers, professionals like myself, and we have compiled a curriculum that is not unlike the curriculum proposed by Legal Services of New Jersey, their landlord-tenant manual. And we have established basically modules that touch on different topics of landlord-tenant law. So tonight we're going to do the eviction process as experienced by landlords. So the whole purpose of this class and why we reached out for this grant was so that we could, establish and help facilitate a better community, a more civil, understanding, less litigious community, if you will. Of course, if it needs to be litigated, then it has to be. But we're hoping that by arming the community with this information, we are giving them the opportunity to, know of each other's rights. So it's just as important for tenants to know their rights as tenants, but it's important for landlords to not only know their own rights, but to know the rights of their tenants so that we can have more civil, more peaceable landlord-tenant transactions and just have a well-rounded, better informed community. So the New Jersey State Bar Foundation was very gracious and very generous to give us this grant to allow us to create this curriculum, have the tech to present it to you in live stream form. So these videos, if you're not enjoying it live as an audience, they're going to be on our website and our social media to be enjoyed. And they've been viewed many times by our prospective clients, by landlords, tenants, area practitioners, service providers, anybody who wants to be part of the solution to the eviction crisis that is going on in our vicinage and the homelessness crisis that is plaguing our state all around. That was Tori, our tech, making a quick appearance again. She just can't get enough of the camera. She's always trying to figure out a way to get into my class. So maybe next time. I have here tonight with me is David Wallace. So David Wallace is an area practitioner. He is one of the lawyers that I have come across in my own work. So one of the grants that I operated under originally when I came to Family Promise was called Comprehensive Eviction Defense and Diversion. And the purpose of that grant was it was from the Department of Community Affairs, and we got some money to go to court and work with landlords, tenants, court staff, attorneys, and try to figure out alternative resolutions to the eviction crisis, whether that was paying the back rent or if there was an issue going on that was related to the eviction. So if there was a crisis of faith, if there was a mental health crisis, substance abuse, domestic violence, we would try to find ways to basically bridge the gap between the courtroom and the area services. And we would work with attorneys like Mr. Wallace and his clients to try to see if we could pay the back rent if it was a non-payment of rent case. So it was a really exciting program. We're still operating it today, but while I was in court and working with attorneys like Mr. Wallace and other practitioners and court staff, I picked up quite a bit of knowledge and experience. And then, of course, while also using the Legal Services of New Jersey landlord-tenant manual, we're able to present this curriculum to you tonight. So just a little bit of background, what brought us to this point. And again, a great and deep and heartfelt thank you to the New Jersey State Bar Foundation, who was able to give us this generous amount of money to allow us this presentation tonight. And of course, thank you to Mr. Wallace for your time this evening and coming to see us at this agency and devoting your evening to us as well. So thank you very much. looking forward to it.
Happy to help.
Yeah, looking forward to having some great information out there, and really, really going to be an exciting class. So thank you very much. So what we're going to do is we're going to jump right in, everybody, and I'm going to go ahead and share my screen with you so that you got. Oops, that is the wrong share. This is the share screen. So we're going to go ahead and share the window. That way, oops. Go ahead and hit that real quick and dismiss. Okay. Let's go back and see if I can do that again. Share screen. That's better. Share that. Okay. Tori, do you mind telling me if we look okay here? Can you see? Oh, yep, we look good. All right, very good. So for those of you at home joining us, you should be able to see the PowerPoint presentation in the background and then see myself and now Tori again in the corner. I think we're looking okay. And then we go watch up. Excellent. Thank you much. Perfect. I appreciate that. Thank you, Tori. All right. So we're going to go ahead and jump right in. So before we actually get into this evening's topic, which again, so we've delved into many topics. So just to kind of briefly just touch on. So before we jump into this evening's topic, and I'm going to pass it over to David, I'm going to be asking him some questions this evening, and he's going to inform landlords out there what the process is, what your rights are as a landlord, what the eviction process looks like, and how that all transpires. So but before we get into that, just a quick disclaimer from Family Promise of Sussex County. So for those of you viewing this now as a live stream, and for our future audience and attendees, what we just want to make sure you are aware of is that Family Promise of Sussex County is not a legal service provider. We are a 501c3 nonprofit charitable organization that specializes in housing crises. So whether we're dealing with individuals or households or families that are dealing with street homelessness, and we are helping rehouse them, or we are helping families who are facing eviction at the risk of losing their home, and we are diverting or preventing that eviction. That is what our case management does. That's what our grant programs are centered around, and that is the work that we do. So we do not provide legal services. We do not provide legal advice. So I am not an attorney. So I cannot legally give you legal advice. Only a licensed barred practitioner like Mr. Wallace can actually give advice that has legal consequence of it. This program is meant to be informative in nature. So if you do have any questions during our live Q&A session, we advise you to seek legal counsel. If Mr. Wallace is comfortable answering your question, that's a different story, but I myself nor Family Promise, we don't represent ourselves in a legal capacity. So just wanted to put that out there. And again, this is informative in nature. Okay, so now we're going to go ahead and just jump right into the material. So tenants have the right to a court process. So an eviction can only be done by a special civil part officer with a warrant of removal that is issued by a judge. So in the state of New Jersey, and I'm going to go ahead and turn it over to Mr. Wallace. So before we actually get into the substantive material for this evening, Mr. Wallace, could you tell us a little bit about your background and, where you studied law, how long you've been a practitioner? Do you do anything outside of landlord-tenant law? So if you kind of want to just give us a little bit of your bio, that'd be wonderful.
Sure. Yeah, I've been practicing here in Sussex County as an attorney since about 1990. And before that, I worked in a big firm in Morristown.
Excellent.
Graduated from Cornell Law School 1987, and I'm admitted in New York and New Jersey, but primarily I'm practicing in New Jersey.
I see.
So
do you get your New Jersey and New York bar? Like, is there what's called is it called reciprocity? Like, did you have to take two separate bars to be able to practice in both states?
I took them both. I got an excellent score.
Wow.
Tell you what an excellent score is. It's passing, but passing with having a great summer.
Yeah.
That's a great story.
Yeah, absolutely.
So-
That's
So
wonderful.
Cornell was beautiful in the summer.
Yeah, yeah. My brother went to Cornell for his undergrad. He did applied engineering and physics up there, and I went and visited him. Was not a Cornell grad, but it is a lovely, lovely campus. Ithaca's a beautiful town, and Cornell Law School is one of the top tier schools in the country. So
So they say.
yeah. So they say. So yeah, we went around to all the places. Ruloff's was a wonderful restaurant that we go to. Yeah, we had a lot of fun in College Town and stuff like that. So beautiful, beautiful campus, lovely. And so that's great to know. So appreciate that background. So what brought you to? So you worked at a firm in Morristown. Did they practice tenancy law, or was it some other type of litigation?
Well, they did all kinds of litigation. I mean, I started working for RJ Reynolds. I mean, they did the other end of the scale.
I got you.
But it's, in a tower with 80 other lawyers, some people love it.
Yeah.
I like being in the country.
Yeah, yeah,
So-
absolutely. And where do you practice right now? You're based in Sussex County. Where you at practicing out of?
Montague.
Oh, okay. Okay, that's a lovely area too.
I'm also from Goshen, New York, which is not far, so
Oh, okay. Wonderful.
kind of
Yeah.
straddle the line.
Yeah. And again, Montague, I think that's pretty much as far as you can go in Sussex County before you start hitting New York State, pretty much. Excellent. Okay. So what brought you to do you practice just solely tenancy law, or is that just one of your areas of practice?
I do a lot with property,
Okay.
so both transactions and the evictions.
Mhm.
I also do other kinds of litigation,
Yeah.
and some estates work. So,
Oh, wow.
after 30, almost 35 years, it's I picked up a number of things along the way.
Yeah, absolutely. Absolutely. So, yeah. So, and again, really, thank you for devoting your time, your acumen, your professional knowledge to what we're going to be discussing this evening.
And a
So,
lot of it's the human element. I mean, when you're working with tenants, they're scared. More than half the time, they're not rational.
yeah,
Um,
yeah, I can imagine.
you're going to see a lawyer because they're in a bind
Right.
and they don't really know what to do. Um, and it, it's difficult. These are also always difficult decisions. You want to be nice,
Right.
but sometimes nice just really postpones the inevitable.
Sure. Sure.
In a really good situation, which is what you were referring to, you take somebody who's in a lot of trouble and you get them into some sort of a process where you talk. They go to family promise, and family promise sort of helps both parties.
Mhm.
The landlord quite often can get a big part of what's owed, and the parties can reach an agreement with the assistance of the court. And hopefully at that point, the tenant realizes, this is serious, and they've got to really make a decision about whether the place where they're living is really right for them or whether they can handle it.
Right.
So that's really where you want to get to. Usually we don't have to try these cases because we can work something out.
Yeah, yeah, that seems to be the case.
Yeah.
When I was perusing through the legal services like manual, because that's been kind of really our roadmap, like here, and trying to learn a lot of this information because it's hard, to decipher a lot of the legalese and a lot of the procedure and things like that. And for a layperson like myself, who's not familiar with the workings of like the court system and how all that goes, it can be really helpful to know that process and to have these services that break it down for you and make it palatable for the parties. One thing that I wanted to ask you about, and as it pertains to the slides as we move forward, I wanted to ask you about, well, really how it all begins, right? So if you could walk me through as a practitioner, like what do you most commonly see in your experience? Like when does it start happening? And I mean from the landlord probably comes to you when they say, and what we most commonly see, at least in my experience, has been non-payment of rent cases. So the landlord comes to you, and at what point is it when the tenant starts responding? Do you often see in your practice that there's a conversation prior to litigation, or is it just like they're at trial and then all of a sudden they're trying to look for a resolution?
They- Usually the landlord's trying to talk.
Right.
Um, and depending how many times they've done this, they either come to me right away or they're gonna let it go a few months. I mean, that's really a difficult decision that people have to make. Is again, you want to be humane, but a lot of times, you're really not getting a meaningful response.
Yeah.
You're
Yeah.
getting promises, and they may be sincere, they may not be. But the problem for a landlord in these situations is generally time and the time value of money.
Mhm.
Because you let 4, 5, 6 months go by, it's very hard to get that rent back. And
Right.
uh, there are two types of potential lawsuits you'd end up with a landlord. One is an eviction case.
Okay.
Okay, the eviction case is just a case where the judge says it's time to leave and you got to go. Court order, a sheriff can lock them out with a certain period of time. The other kind of case is a collection case.
Okay.
They cannot be the same case. They got to be done separately.
Okay.
Right. So the landlord tenant court can move very quickly, but it's only going to deal with the eviction issues. Landlords often think that they can collect money when they go through the eviction process. They can't.
Right.
That's the second case. And my feeling about collection cases, I've done them. I really try to say to a client, a landlord, look, you really got to think about whether you're going to get any money
Mhm.
uh, at the end of the rainbow year, or whether you're just going to spend money.
Mhm.
That can be a very difficult decision.
Right.
So, I mean, if every tenant had money in the bank where you could bring a collection case and get paid, then
I see.
we wouldn't really have the same concern. But when generally that kind of collection is so difficult in the landlord-tenant world, and can be very expensive, is again, time becomes a really important factor for a landlord. And a landlord could be struggling with, carrying some of the utilities, some of the taxes, mortgage payments, and they don't always have the luxury to wait.
Yeah.
Um, so you've got to evaluate the time and the economics from the get-go to make a decision about what's the right way to go, what's worth doing.
Right.
The advantage of the landlord-tenant process is that, yeah, it seems mean,
Sure.
but when promises are one promise after another is broken, the parties are not communicating,
I see. Yeah.
and
Yeah.
somebody may not be realistic about where they need to be.
Right.
So in a good situation, unfortunately, the case has got to be brought. It's, I'm sure for tenants it's terrifying. It's unfortunate,
Yeah.
but when the day of court arrives, and it arrives fairly quickly here in Sussex County, you'll get a trial within about a month and a half.
Oh, wow.
Or
That
or
quickly.
at least an appearance date, usually within 2 months. So
Okay.
it's really not bad at all.
Right.
Um, but when you get to that date for a trial, first thing you're going to do is have a conversation, and it's going to be mediated by somebody from the court.
Mhm.
Now you can try to have a conversation before you show up, and as you suggest, the more you can talk and talk honestly and frankly, the better off everything is.
Yeah.
You can reach an agreement before you come to court. On occasion, I've been able to do that, and to save time and trouble and money,
Sure.
save
Sure.
attorney's fees. If you can do it, it's a great thing to do.
Mhm.
But then when you get to court, they'll make you do mediation, and more often than not, people are going to walk out of that session with what's called a consent order, which is an agreement which eventually gets signed by the judge, which is enforceable.
Okay.
And the consent order may provide for payments to be made, if that's the deal that you make. Every now and then, a landlord will give a discount to try to make a situation work.
Mhm.
Um, or they'll take payments over a period of time. And sometimes the tenant will say, well, you're right. I know this isn't gonna work. Let's just come up with a reasonable schedule for me to leave.
Oh, see, yeah, okay. So, and it's realistic, you know what I mean? Yeah,
That's right.
yeah,
So, yeah, it is adversarial, but it does end up being a discussion about how to resolve things amicably. And family promise obviously can make everything a lot easier for everybody
sure.
by paying some of the rents to
Yeah.
make some of this difficulty more economic.
Sure. Yeah. I really wish we had a magic checkbook. We could help everybody. But I think with the grant money that we have, you know, I could probably spend that in one day in court in Morris County with the money that we have. But you're absolutely right. And I think that's a great point. Um, that communication early and trying to settle prior to the actual trial date so that, you avoid the expense of court costs, any additional late fees incurred, or any other non-payment of forward monthly rent that could get subsumed into the claim. You can come up with a installment payment and things like that. Because I've been in court when, whether it be Judge Weaver or whomever takes the bench, and they read the Harris announcement, and especially Judge Weaver, I think when he breaks from the Harris announcement, and he'll say, he'll really encourage settling, because he'll say you have a lot more discretion when you settle. You can try to create terms that are fair and realistic to the parties. Whereas if it's in those non-payment of rent cases and you go to trial, his hands are tied, so to speak, because he'll say, well, do you have the rent or don't you have the rent? So it sounds like the lawyer and an attorney like yourself really plays a pivotal role in instructing your client to help develop a deal. Obviously, your advocacy is for your client and for the betterment of their circumstances, but it sounds like your decision and your negotiating tactics and skill could really serve to benefit both parties. And we come in that way from Family Promise as well, because we look at it objectively. Yes, we're tenant focused, but we understand that landlords also sometimes, these are properties that they have mortgages on that they have to pay. And this is their sole income earning, aspect of their life. So it's kind of like feeding an ecosystem. So we pay the rent to keep the tenant housed, but it also keeps the landlord operating and serves that business as well. And they may have other properties that they have that they're keeping tenants in, and on it goes. So we see it as a really important element, and working together as a team has been, tremendously important.
I think, if I'm correct, your team doesn't generally get involved until after eviction's filed, right?
So it depends on the grant. So and sometimes it's made as an agency decision as well. So it depends on how much money we have. We may say, okay, in order to just like, close off the floodgates, we may just say, okay, let's wait till we have strictly docket numbers, because otherwise we're getting overwhelmed and we just don't have the staff to be able to deal with all these claims that are coming through. Ideally, with the CEDD grant that I had mentioned at the beginning of this session, the time that we want them to come to us ideally is the moment they say, I lost my job and I can cover this month with my severance, but next month is going to be a real struggle. And that's when we will try to find whether it's an area service provider outside of the agency, some funding stream outside of the agency, or we'll look within and say, okay, let's get this taken care of now so that you don't have to have this contentious relationship with your landlord, and you can try to look for another job and not have to worry where you're going to scrounge up money and things like that. Because that's when it's manageable, like you said, because when you make those decisions with your client and you say, okay, we have to make a decision. Is this something that you want to pursue litigiously? Do you want to wait months and try to be friendly about it? Because sometimes I've had this discussion with my colleagues and I've said, sometimes I wish in some instances that the landlords were more litigious, and they would, as soon as that fifth day, that grace period they get passes, I wish that's when they would file the lawsuit, because sometimes we don't hear of it or get to it until the day of trial. And many months may have passed and the amount of arrears has grown, and our ability to help resolve or rectify the circumstances diminishes with the amount of arrears that grows. We can get to it early before it metastasizes, so to say.
Yeah, I think that's a great observation. When I get involved with somebody early on, I mean, what really drives my advice is going to be, is what does this relationship with a tenant look like?
Mhm.
If all you're getting is nonsense, my advice is let's go.
Right.
I mean, and I know how cynical and mean spirited that can be, but
Mhm.
you're sort of showing the flip side is you got to get at it, get down to business,
Sure.
figure out what you're going to do with your life as a tenant.
Mhm.
So with landlords, the clock is ticking, and you have to make that evaluation of whether you're being played,
Mhm.
whether
Sure.
you're being ignored,
Sure.
or whether somebody's being dishonest, or whether they just they don't know what they're doing. They're sort of deer in the headlights.
Right.
It's not always easy to know what you're getting.
Right.
Sometimes if you can't figure out what you're getting, you don't know when this bad situation is ever going to end. So the solution is to go to court as soon as possible to trigger the kind of discussion that you're talking about,
Mhm.
where we can really try to get to we rip the Band-Aid off for
Right.
this tenant
Right.
and get to a meaningful discussion about what's going to work and what isn't going to work.
Yeah. Well, I think that was one of the problems, the resulting unforeseen problems of the eviction moratorium that was related to COVID. Because once that was lifted, and that coincided with the beginning of our first grant cycle with CEDD. When we went to court, we would see these arrears cases that were north of $20,000, $15,000. And we said, this is unmanageable. We can't address
Sure.
this. You know what I mean? So obviously, the earlier the better. Um, but
And
oh, go ahead.
if you have a process where you don't have to go to court, that's great.
Sure.
And
Yeah,
my attitude is anytime a tenant can get in front of objective, if I'm for a landlord, a tenant can get a second opinion,
Mhm.
that's objective, I'm all for it.
Yeah.
I want all the cards on the table, communication flowing, everybody knowing where they stand, so we can make decisions.
You got it.
Because more often than not, the problem is that you really don't know clearly what you're dealing
Mhm.
with a tenant. I mean, because when they get scared, and I don't know if there are any tenants who are actually on this, but you know, something to think about is that when you're in a situation where you can't meet all the obligations that you have, I think one of the best things you can do is to show that you're serious about having a discussion.
Yeah.
Now, there's some landlords you probably can do well by taking advantage of them by doing nothing as long as you can.
Sure. Yeah.
But my advice is always going to be, let's go.
Yeah.
Let's go to court yesterday
Sure.
to get an answer to what we're doing here. So you don't keep losing months worth of rent. But if there's somebody who's proving that they really want to face the issue,
Mhm.
whether they can meet all their obligations or they can't, I mean, that's got to be taken very seriously.
Yeah.
It shows an opportunity you can avoid um, expense, delay, and economically, you might end up doing better. You might end up with a great tenant
Mhm.
who's responsible enough to communicate.
Right.
I mean, that can really be very important for a landlord.
Absolutely. Yeah.
I mean, sometimes you never really know what you're getting from tenants, so you want them out of there
Mhm.
so you can start again. But if the tenant says, "Look, I lost my job, but here's $100.
Mhm.
And I'm not saying that this is all I owe you, but I'm trying to show good faith. And
Right.
I want to have a discussion with you. I want to work it out. I want to show you that I'm not hiding.
Right.
So, and if we can put an agreement in writing, I'll do it. I'll make payments. And if I can't pay, then I'll agree to go. Or maybe you'll cut me a break just because I'm being so responsible,
Sure.
really
Yeah.
trying my best."
And I think that's one of the through lines I've been discussing. So since we've started these courses, the thing I've always been, communicating to my attendees in this class is communicate, communicate, communicate.
Mhm.
Like the moment you feel like you're not going to be able to make this work, way before, any notices or trial or anything like that, reach out to your landlord, contact them, don't hide from it. like you said, pull the Band-Aid off, and just get it done. Do the responsible thing, because you're going to benefit from it. The more responsible you handle this and the more communication you're able to do, the better the situation is certainly going to be. Because I think hiding is what's going to end up making it more costly at the end of the day. And that only serves as evidence against the tenant that you have no good faith, right? That you have no intent of paying, or at least that's what it appears to be. And it may not necessarily be the case. You may truly just be scared, you know what I mean? But
things
it
can
helps.
really escalate. The bad feeling
sure.
can escalate. It makes
Sure.
it harder and harder and harder to try to resolve a case.
Yeah,
And resolving cases amicably is how you save money ultimately.
absolutely.
I mean, the ostensibly a tenant could be responsible for attorney's fees, but at least half the time that doesn't happen.
Hmm.
Because their leases are not written correctly.
I see.
The lease has to say that unpaid rent or attorney's fees. I'm sorry, attorney's fees are considered unpaid rent. They're considered additional rent when landlord has to spend money to address a default by a tenant.
I see. I see.
And sometimes Family Promise will even pay that, which is obviously great for me.
Sure.
Yeah.
Sure.
And sometimes all it does is it makes it harder for a bad situation to continue.
You got it. Yeah.
And by that I mean what landlords need to know about eviction is that they go to court, they might reach a deal. If they don't, the even if they get an order for eviction, the tenant can stay if the tenant pays everything the tenant owes.
Yes. Okay.
All right.
Yeah. So what you're saying is, well, excuse me. So even in the face of having that judgment, the judgment of possession from the court, and even a subsequent removal order, the warrant of removal, they can still, up to a certain point, pay to restore their tenancy, to either stay or.
That's right.
Okay.
That's right. So what the additional attorney's fees make it harder for them to do that. Sometimes you want it to be hard.
Mm-hmm.
I mean, because if it's a really bad situation where maybe the property's being destroyed, that's the more common situation, is where they don't have the money, they're never going to be able to be current, or they're really destroying the place. They brought in dogs they're not supposed to have or something like that. Easiest solution is the non-payment case often.
Gotcha.
Particularly if the attorney's fees come into the picture.
Mm-hmm.
So you've got to look at your lease and see whether the additional language is in there. If you have a realtor's lease, an NJAR lease,
mm-hmm.
that lease typically does not have the right language unless the realtor had the presence of mind to put it in there as an addition.
Regarding the fees?
In addition to the form, the pre-printed form does not have this language.
I got you. So it's just boilerplate, kind of generic.
That's right.
Yeah.
That's right. If an attorney prepared your lease, probably it's in there.
Gotcha.
There's other ways to address that situation, and it has to do with this issue of, settlement. I've made settlements in court. We agree to have some money paid, but we also try to fix some of the other issues in the case. Like we provide that additional language, the tenant agrees that this will apply going forward, this lease language about unpaid attorney's fees being additional rent. You can sometimes cure security deposit issues as part of the process. I mean, you want to be creative to get as many issues resolved as possible and to do it in writing.
Gotcha.
Which of course is the gold standard at any point. I mean, you always want to if you can make an agreement in writing, you're always in a better position. Doing it in court, again, sounds like we're trying to tell everybody to get into a lawsuit, but as you said, sometimes it really is. It's better for the tenant. It's better for everybody to get it in court, to get it worked out if it can be worked out and resolved that way.
Right.
One thing about that process is that when you get into court and you have this mediation discussion, if you can make an agreement, quite often we're going to have an agreement which says the rent's got to be paid by XYZ date. Okay.
Right.
Now, and so what that means is you can reach an agreement that has a pretty good measure of finality, and you can be out of the courthouse before lunchtime
Hmm.
with a written agreement that the judge will eventually sign and file. If the tenant doesn't do what they're supposed to do and pay what's in that consent order, you immediately file a couple of simple papers, and you're going to get an order for eviction.
I see. I see.
So the consent order is also something I counsel people to try to get to. Sometimes we get to do before we get to court,
Mhm.
because you want to knock down those attorney's fees as best you can.
Sure.
You don't want your attorney sitting around in court for a day or, God forbid, 2 days.
Right.
And
Right.
sometimes that'll really happen, with the attorney's fees can really be a problem because the courts are very liberal about some of the scheduling issues.
I see.
So you can show up to court, uh, to have thinking you're getting a trial, and literally the tenant went to the emergency room that morning
Sure.
with a hangnail,
Sure.
or I mean, God forbid it's something serious. Every now and then, I suppose it is, but sometimes these excuses don't seem all that credible to me. But
Sure.
there's not a real searching examination of these excuses. They typically get the extra
Sure.
time.
Sure.
You have to come back in a week or two, but your attorney's made an appearance, incurred the time, incurred the fees, and you got to come back. Those things can be costly.
So that's an excellent point. So, like, and especially if we have a lease, like you say, that has that language that, that attorney's fees can be recouped, as, unpaid rent in the lease. And those fees can build up. So the interesting point is that we've had a video that deals with the eviction process as experienced by the tenant. So the flip side of what we're talking about right now. And in that, I listed, and folks, for those of you who are watching and joining us right now, and those of you viewing this in the future, I took down the slides because David and I have started engaging in this really interesting conversation about the court process and just theoretically about what is more beneficial to the tenant and the parties involved in a landlord-tenant litigation. And I thought that you would enjoy just kind of seeing us have that discussion rather than just following the straight curriculum about it. But one of the questions I want to ask you, David, because what we were talking about, what I've been talking about in that prior class, the eviction process as experienced by a tenant, one of the tools that is listed in the manual and that we've made available to our attendees and our recipients of this information is that they have adjournments and postponements as a tool in their toolbox if they need time to get their ducks in a row, or if they want to reach out to their landlord and attempt a settlement, or heaven forbid there is an actual emergency and they're not able to attend court. Now, ideally, you want to reach out to the landlord's counsel, or you want to reach out to the court before your trial date. But always communicate, communicate, communicate. But I can see that advice or that information about using an adjournment or a postponement to your advantage could actually serve to your detriment as it relates to attorney's fees. Because, like you said, as the counsel for the landlord, you've made an appearance. You've been there for a day, you have to come back. Now, that additional day you have to come back, you're charging for that, you're billing for that. And so, if the tenant ultimately ends up losing their case, those additional fees they might have to be responsible for. So it could be potentially problematic. So again, I think the whole point of that is to really assess not only the strength of your case, but the realistic outcome of what could potentially happen. And part of the communication process, I think, that's really important about having it early on is to say, because one of the first slides that we had up while during our discussion is that only a special civil part officer can remove a tenant. A landlord cannot physically remove a tenant from the property. So even in the face of threatening phone calls, or really upsetting conversations, or a notice to cease or a notice to quit, even receiving the summons and complaint, they do not have to leave until, literally a special civil part officer is removing them from the property. But it might be best at that time to reach out to legal services and say, and talk to your family, talk to your friends, people in the community, and say, is this really the best decision for me right now? Do I avoid the risk of having an adverse consumer report, right, and having the eviction filed against me, having judgment of possession on, adversely or deleteriously affect my credit report? Or do I just say, you know what, this isn't working out right now? Can we agree, landlord and tenant, can we agree that maybe it's best that I just leave, and maybe we can come to an agreement where I make installment payments or anything like that? And maybe my parents live in town, I can go stay with them for a little while, things like that.
Because there are services which will report on people who've been through eviction.
Yeah, absolutely. Yeah, and we deal with it all the time in rehousing folks, that there's literally a tenant score.
Yeah.
And it's 1 from 100, and having an eviction on your record can be tremendously detrimental to that score.
Sure.
It could really affect your ability to find additional properties. When you are working with landlords, because I know it can be a particularly contentious process, and although it sounds like your work is collaborative, but it also is adversarial. Do you find yourself in your position as a lawyer having to advise landlords, no, don't do that? Like, do they come to you and say, gosh, I really want to throw this person out. I want to shut off their electricity. I want to turn off their water. I want to just yank them out of there right now. Or do you find that landlords are often more peaceable, and they're more logical, rational, business minded, and they're trying to just get to the end of the process and do what's right by their tenant? Where do you come in on that? Like, do you usually see yourself kind of calming them down and advising them what's wrong and what's right, or do you usually find yourself saying, oh, this is a little bit more civil than I had thought?
I think for a lot of people, it's always a struggle
Hmm.
to really maintain their emotions.
Yeah.
And I mean, you really have to be careful as an attorney that you don't feed into that. You really want to stay clinical. I mean, you feel sorry. Some of these landlords can really be put into quite a lot of financial stress by these difficulties.
Sure.
But at the same time, I mean, the the script and the flow chart to do these evictions is not it's not rocket science.
Right.
I mean, how the court handles adjournments. I mean, how they handle the extra time after an eviction order is issued when somebody says, I'm not ready to move, how they handle non-payment,
Hmm.
how they push everybody into mediation. I mean, there's not a huge amount of variety in the steps that you pursue. The only variety is, you got to move, and typically you want to move with haste as a landlord's attorney. But when people are angry, it can be very frustrating that you've got to go through these steps, and landlords can be very frustrated with their tenants.
Hmm.
I mean, I told you an example. It was a real example, but I showed up on the day of court, and the tenants had actually, it was even after we showed up. We had a default entered against this tenant for not showing up, not
Uh-huh.
saying anything. And after we'd been there, they basically communicated, well, we had to go to the emergency room. And to be quite honest, I don't think that this was any kind of a serious illness at all.
Sure.
But what it was this tenant really did not have a grip. In other words, it was more extreme anxiety than it was anything else.
I see what you're saying. Yeah.
And when you're a landlord and you're busting your rear end every day to hang on to a place, make it nice, and make some money, work on a retirement, that kind of thing. You know, some people don't seem to be able to do that.
Right.
And a lot of it's, the level of anxiety that they have.
Sure.
They're such deer in the headlights,
Yeah.
that it's really hard to understand where they're coming from. In a way, as a lawyer, you don't really have to worry about that so much because the the process is just not that complicated.
Sure.
I mean, you get experience with how the judge is going to treat certain requests.
Right.
You know what to expect, so, you know, shouldn't get your knickers in a knot about what's
Right.
going on.
Yeah.
You
Yeah.
just gotta follow the steps and do your best to move it along. But, you know, some tenants really have a hard time coming to grips with the situation that they're in,
Yeah.
whether it's their health or their finances, whatever else it is. I mean, they just don't know how to pick up the phone or do what they've got to do half the time.
Yeah. Yeah, and I think that's where our case management comes in here at Family Promise. And I think that's why, we could be such an effective tool in the community because even if, for instance, let's say that we are unable to pay the rental arrears and the fees associated with the case in front of them, we can at least get them connected with legal services and encourage them, pick up the phone, get the representation so they can come to the negotiation table with folks like yourself and your clients and say, hey, you've got allies on your side, and we can help you with developing a fair, realistic settlement agreement, that consent order that will allow you to move on with your life or everybody to move on with their life and get what they want out of it. And then if there are issues that are at the underlying cause of why they even fell behind with their rent, whether it be mental health, whether it be substance abuse, whether it be domestic violence, employment loss, whatever it may be, we're here to help prepare them to develop any kind of strength in their system to be able to move forward with their life. We can connect them with the resources. And that's what I love and the beauty of this. And programs like CEDD and this live stream that we're doing right now, I think has been really important in allowing to see how we work as a community because we've shared, although you represented the landlord, but we've really worked together to help the benefit of the client. And it's been really great work. And then even having you communicate your knowledge here right now with our attendees, I'm really, really grateful for. And I think it's a microcosm or an example of a really great collaborative overall process. One of the things I wanted to ask you about was now, as we're moving forward and we kind of make an understanding of what landlords can and cannot do as we establish the eviction process in general as it pertains to landlords, what if you can explain for our audience what exactly, because one thing that I come across in New Jersey and what my understanding is that New Jersey is a very tenant friendly state. And it seems to be that there is, I don't know if it's statutory or how it comes to be, but I see the Anti-Eviction Act a lot. That comes up a lot, and it's come up a lot in the LSNJ manual. Could you explain what that is and why that is so important in in establishing the grounds for eviction?
Yeah, it's anti-eviction act is pretty complicated.
Mhm.
Um, when your lease is up, you don't automatically get an eviction.
Okay.
The anti-eviction act is still going to protect the tenants as long as they are playing by the rules. Um, the anti-eviction act does a couple of things. It creates, you know, a not so tenant friendly environment for non-payment cases.
I see.
I mean, non-payment cases are bing bang boom. They go pretty quickly.
Okay.
So, I mean, it can be a bit painful for the landlord. It does seem a bit tedious, but in the scheme of things, relative to other court proceedings, it moves pretty quickly. It's pretty regular, and if somebody's not paying you, um, there's not a lot of mystery about what's going to happen as a general proposition. Um, Now, to get there, and there's so there's a distinction between non-payment cases and other cases like other lease violations, like noise, destruction of the property. Maybe somebody got dogs, maybe they got too many families living in there
Okay.
that aren't permitted under the lease. Um, Pretty much all those other issues, you have to give a notice to cease
Okay. Yeah.
under the
What
Anti-Eviction
exactly
Act.
is that?
It's basically is a written, properly worded form that's got to be
Okay.
clear.
And just a moment, I'm just going to stop before a brief moment. I'm sorry. Hey, Tori, are you available? So I thought it was a great time to bring up our slides, but that's okay. We can edit them in after the fact. So please continue with.
So I'll give you an example.
Mhm.
When somebody's habitually late,
Mhm.
they're just never paying on time, you don't automatically get a right to bring an eviction case.
I see.
You've got to send them a notice to cease, and you've got to give them, like every violation has a period of time that you have to give them to mend their ways.
Mhm.
Either get rid of those extra dogs or stop being habitually late. It's usually either 30 to 60 days, depending on what the violation is.
Okay.
Or to clean up the place if they've really maybe in a mess. Some things are a little more immediate, like, when there's a conviction for violent offenses, that kind of thing. Those kind of things can move much more quickly.
I see.
But generally under the Anti-Eviction Act, you either get non-payment, or without a criminal situation, you've got to give a notice to cease and give them an opportunity to mend their ways before you can bring the eviction case.
I see. So in non-payment of rent cases, does it require a notice to cease? Or are you saying no, it does not?
No, non-payment is not required.
Oh, say. So short of it being, so anything outside of non-payment and like a criminal, violation, then it requires, what you're saying is this notice to cease. And that is basically putting the tenant on notice that
They're going to be evicted unless they cease their violation,
I see.
either of the rental terms, or hopefully there's a written lease of the written lease terms.
Okay, so somebody who is, like you said, a noise complaint, and it's, and they've got a lot of things, parties going on late in the night and things like that, and it's disturbing the other people nearby, or maybe the same,
Right.
people in the same property, other tenants, and the landlord has asked repeatedly to stop this behavior, and it doesn't. This notice
It's got to be in writing.
got to be in writing.
Got to be delivered. You want proof that it's delivered.
Okay.
I'm all for self-help in a lot of areas, but I've seen people try to prepare their own notices to cease, and
Just doesn't want to communicate the points.
the court's going to be fairly technical on
Ah.
whether you've done it the correct way.
Gotcha.
So, your money is probably well spent to get a lawyer to prepare it for you.
Sure. Yeah,
Get it out and
absolutely.
get it served the correct way.
Right. Right.
The other thing that comes up is that, we were talking about whether somebody has to leave at the end of the lease. I mean, there is some statutory basis to sort of up the ante with a tenant, at the end of a lease. If they agree to go and then they don't,
Mhm.
there's a statute that provides for some enhanced obligations, double the rent that the tenant's got to pay.
Mhm.
Something similar for when they won't accept reasonable terms that have been proffered. At the end of the lease, you can raise the rent.
Mhm.
You can propose additional terms, like no more dogs, or no noise after 9 o'clock, or attorney's fees are, I don't know why I keep coming back to that, are considered additional rent. But at the end of the term, there are some things you can fix.
Mhm.
And if the tenant won't accept reasonable terms, and you've got a remedy under the statute, and be complicated, talk to a lawyer. You
Sure.
could even get double rent where they're not behaving correctly. So there are remedies for it, but as a general proposition, if the tenant is doing everything that they're supposed to do, they get to stay,
Gotcha.
subject to reasonable changes that a landlord, you know, offers to them in writing.
So basically, a tenant, like, just because their lease term comes to an end, that's not grounds for eviction. But what you said is that a landlord can, at that time, I guess, with proper notice, provide for a new lease. What happens in those cases where, let's say, the landlord proposes a rent increase? What happens in those cases where, because I've seen that in court. Now, obviously, I don't give legal advice, but I do have tenants, or not, excuse me, not tenants, but clients who are tenants, and they find themselves in landlord-tenant court, being sued for eviction because they didn't adhere to changes in the lease. and that being rent increases.
Yeah,
So what about that?
if a reasonable rent increase is proposed and not accepted, that's a non-payment case.
Oh, wow. So it's just as simple as that.
It can also be a habitual lateness case.
I gotcha.
So
Okay.
with a notice to cease, you could go either way. So you would set up to resolve some of your issues, and you can do that at the end of a lease term.
Does the court always look at those non-payment of rent cases? Like, do they automatically just say you got to pay this rent increase, or are there certain rules that dictate the rent increase itself?
I mean, there's sort of a rule of thumb. Um, I think it's even like it's not very much, like 7%.
Okay,
I mean, those kinds of things are fairly discretionary with the court.
I see what you're saying. Okay.
Um, and obviously, the economic environment we're in, there's a lot of, you know, talk about inflation, those kinds of things.
Hmm.
There can be situations where a higher increase is warranted. For example, if the rent has been artificially low for too long,
I see.
you know,
So there's a
it's
lot they take into consideration.
it's about reasonableness.
Right.
I mean, let's say you had a conversation with the tenant, and you say, look, I'll put in new carpet if you'll pay me, I don't know, pick a number, an extra 50%. I mean, in theory, you could put money into the place
Hmm.
if there's an understanding with the tenant. I don't think you can do it unilaterally.
Right.
And if you have relied upon what the tenant has said, it's
Hmm.
always better to put that in writing. But you could argue that that's a reasonable basis
Hmm.
for a higher increase.
Hmm.
So it's all a bit touchy feely. One place to look on that consideration is if you get the legal services handbook, which
Hmm.
is available online. I mean, the
Right.
legal services handbook goes through that, and they have a number in there that they recommend. And I
Yeah.
think it was like 7%.
Yeah, and I spoke. We had David, one of the legal services attorney. His name's David Saltzman, and was on our class or live stream last week and touched on rent reasonableness. And he, like yourself, or he touched on reasonableness. That seemed to be I can't recall the exact number that he had mentioned, but it seemed to hover around like 10%, so give or take a few. Because I know like the LSNJ manual will talk about there are, ordinances, town laws that control rent. But outside of that,
That's true.
the court looks at several factors. It appears that,
Not so much up here, but
right,
there
right.
are rent control certain places. And yeah,
Yeah,
I mean, I think of late, I mean, the market's been a little hot, so that 7% number, I mean, I'm sure I saw that, 4, 5, 6 years ago. So,
right. But like you said, that
probably,
reasonableness,
arguably it's more now.
yeah, but that reasonableness, it's like it seems to be kind of an all-encompassing like term. Like reasonableness, I see a lot in the law as well. Like what a reasonable person would consider, and this other thing like shocks the conscience of a reasonable person and things like that. So, but when the court looks at, I guess, rent increases, it seems that, like you said, reasonableness being the gravamen or like the central point, and that there's lots of considerations in that, like
That's right.
if there's properties that are doing something similar in the area, what have they been paying over the past years and things like that. Have there been any updates to the amenities in the apartment? So it looks like the court has discretion with regard to that.
The court has discretion. Everything we say here about this
Right.
is sort of you're trying to maximize your advantage,
Right.
minimize your risks. At the end of the day, it's the judge's decision.
Sure. Yeah. Okay. All right. So, as we move along and, we move forward from like the notices, it seems like after the notice to cease, are there additional notices that are required, for the landlord, like, after the notice to cease?
To terminate the tenancy, it's a notice to quit.
Okay. And
Again, it's a particular form. It's got particular wording.
mhm,
Not a bad idea to get advice. I think does get to be a bit confusing.
Sure.
And the court can be very technical about what they want to look at. And again, we're not talking about a non-payment case.
Right.
We're talking about,
Oh, okay, right. So they're not due that notice for non-payment of rent cases. Okay, and that seems to be the most common case that we see, at least in my experience, and when I'm in the court, and again, I'm not an attorney, but what I view as a social worker is that a lot of the cases that you and your fellow attorneys are litigating about seem to be largely, if not exclusively, non-payment of rent cases.
usually, yeah. And in those cases, I mean, if you're a rental agent with a bunch of, handling a bunch of properties, for different people, you probably want to send out a notice under the Fair Debt Collection Practices Act
Okay,
early on.
I see.
Because what's happening it could be deemed an effort to collect a debt.
I see.
So this particular notice, I mean, if you're professionally doing those kinds of things, you probably are aware of that statute, just something to make note of that you shouldn't forget.
Okay.
There's a couple basic preliminaries before you start an eviction case. And I see you've got defenses up on your screen.
Oh, sure. Yeah.
It sort of bears on that as well. And this has to do with the physical condition of the property.
Mhm.
You cannot bring a case for eviction, and no lawyer typically is going to entertain it, file it for you until you have the required registration as a landlord in the municipality where the premises is located.
I see.
Um,
So when we talk about when we're talking about defenses, um, with like the failure to register the property, is that an outright, like if a tenant brings that up and says, "Hey, this property wasn't properly registered with the municipality," is that going to dismiss the case like outright? Does that mean like, "Hey, you failed to I live in a property that isn't registered, therefore it's not a proper tenancy, and this case is over."
Subject to the evidence, typically you're done. And
Really?
and you'll have to register and then refile.
Okay, so you can still go back to court.
Yeah.
I got you.
Yeah,
Okay.
typically you'd be able to refile once you resolve your concern. And when you are looking at this landlord registration stuff, something is a little new the last, not at least in Sussex, the last year or so, is you
Mhm.
actually have to file that when you start your case.
Mhm.
So it's pretty important to have it. In most of these municipalities, you've got to register with them for inspections every year and pay a fee.
Okay.
There's a fire safety inspection, but they're also typically kind of snooping to see what else they can find.
I
It's
see.
it's a it's an opportunity to be heard. But it's the way it is. If you want to be in eviction court, you have to register and typically let the municipality into your property.
I see.
And that means, you don't want to have work that they would find which is unpermitted because you might get cited for that.
Okay.
If you do get into a situation where you may have an issue of habitability, there's a couple of things about that. I mean, I had a case where, when I was actually working for the tenant, the landlord had added bedrooms which were illegal.
Oh no.
You
Oh,
know,
wow.
they lacked lawful fire egress,
I see.
and the municipality actually, you know, had limited involvement and said that this occupancy was partially illegal. Now, the real risk for a landlord is if you bet wrong on that, it can go very wrong.
Right.
Because if you miss, I had a tenant, wasn't anything they could do about it, but they had a house where the structural support was very seriously compromised.
Mm-hmm.
So the place wasn't safe. They found out after they bought it. I mean, there was some, I don't think it was termites, but there was some hidden flaw in the place. They had to pay 6 months of rent and the cost of relocating the tenant.
Wow. Wow.
Yeah. And there's case law that suggests they could even be forced to pay that, even if the tenant's in arrears.
No kidding.
Yeah, so the physical condition of your property can really be a concern if you're not on top of it.
Right.
Um, but that's all triggered by this inspection process to get your property registered. You need to look and see what your municipality requires.
Mhm.
Typically, the building department will have a set of forms for you to tell you what you got to do, how much you got to pay, whether you got to do it every year, which I think is increasingly common.
Hmm.
And then um, what you see when you get into the trial process, you see the defenses. Mostly, the defenses that tenants raise are not very good defenses.
Sure.
They'll say I'll just pick a bad example is that, the paint's peeling. So I shouldn't have to pay my rent.
Right. Right.
And
That's actually a great example because what I will commonly see or what I've witnessed or observed is that when you mention habitability, because I know there's a whole complex process to habitability and Marini bonds and hearings and things like that that I have no business talking about, but I know it's very complex. But what I see mistakenly done is that, and to your point of weak defenses, is that tenants will often assert habitability as a defense in reaction to a
yeah,
non-payment of rent claim initiated by their landlord. So the landlord says, "You haven't been paying me rent." They end up in court, and then at trial, the tenant will say, "Well, I didn't pay you rent because this place is in a state of disrepair." And even if that may be true, there's a whole process to that where I believe the landlord has to be put on notice, and the money that the tenant would have spent on rent has to go in an escrow account. And there's a whole process to that.
that's the way it's supposed to work.
Right.
I had a particularly difficult case. The tenants were just making stuff up, just really obnoxious.
Hmm.
Um, taking down realtor signs and just trying to impede any effort that the landlord had. And it was just clearly, I mean, I'm sure they felt offended, for whatever reason. People have their reasons, but
Sure.
I just thought everything was quite unreasonable. It just made everybody, including me, pretty angry about it. So
Sure.
you really want to end this as soon as you can. So we show up on the day of trial, and the tenant says, "Well, Judge, I got a defense. I have mold
That's common too. I see that.
in my house," and we'd been through a bunch of leaks that nobody could find before that in other parts of the house. I mean, there was just stuff which just couldn't be documented because it wasn't real.
Mhm.
Um, and with really, as I said, the court always has discretion on how they're going to handle these things, and they have conventions and routines about how they do it. And I said, "Well, Judge, today's the trial date. They haven't put this money into court,
Mm,
so let's try this case. Let's go. We want to end it.
right.
We don't want to have to come back. It wouldn't be fair to the landlord, extra expense, yada yada."
Sure. Sure.
And the judge said, "Well, how I do things is that I'm going to give this tenant a period of time to come up with money." So what you were alluding to is what has to be done in what's called a Marini case. Marini's a case is deals with a situation where the property is not habitable. In other words, it's got uh, serious defects. Maybe like lack of hot water. It would be one, lack of heat, obviously. Significant um, deficiencies that depart from what should have been provided under the lease. But the tenant has to put up the rent,
Okay.
and then the tenant gets a trial.
I see.
So you could pay it into court. There's a procedure to pay that rent into court. So you have so-called major deposit. So that
Okay.
if you lose at trial, then the landlord gets paid.
Mhm.
But without doing that, you don't get to have a trial on the habitability of your property.
I see. I see.
Um, and that's if, for some reason the building department doesn't shut it down, then,
Right.
the trial is sort of a moot point. And that's pretty rare, but, um,
So even if
So
a
that,
tenant,
that's Marini. So
so even if a tenant has substantively like a habitability claim against their landlord, they have to follow that procedure, or does
yeah,
it nullifies their point?
they gotta bank the money.
Wow.
They gotta bank the money. They gotta bank the rent. Then they get a trial on the issue.
Wow. So that's a really, important thing, that, but it's important to know for landlords too that they are due their notice, right? And that there's a procedure to things as well. And I think it's important to use that as, as we're talking about these subjects here, it's important to know why we're talking about them, because the whole point of this series, and really the purpose of this evening's course is to talk about, landlords, and their rights, and what the eviction process is like for the landlord, because they are part of the ecosystem. Again, Family Promise of Sussex County is a tenant focused organization. We deal with tenants here, but again, the work that we do helps serve the overall ecosystem, because we feel that it's important when we make those payments. When we hand over a check from Family Promise of Sussex County, we're making that payment to the landlord, right? And we understand that the landlord, it's very important. This is a business. They need to get paid as well. They have bills, they have responsibilities, they have a livelihood that they have to maintain as well. So this knowledge is just as important to them as well as it would be to the tenant, and it helps to mend that relationship. It makes this process that much more easier, peaceable, and civil, and much more well informed. Um, as we move forward, and kind of cap off the evening. And again, thank you so much for your time, David. This information was exceptional. It was thorough, and it was so thoughtful. I really appreciate the time you've devoted to give to our audience. One thing that I wanted to touch base on in the last bit of time that we have here is walking through, if you could just kind of walk us through, because I think we talked about all of the things leading up to trial and what the trial experience is like, and the discretion the judge has, and even great examples of the things you might experience in trial, from non-payment of rent to habitability claims and so forth, rent increases. um, what is it like then for you as a practitioner when you go to trial and you have that hearing? Is it like a trial that for landlords that have never been in the litigation process, or even for our tenants who are watching this particular episode? What is it like? Is it like you see on television with like, is it like a typical trial where you have direct examination, cross examination, and then what ensues after that? What happens when the judge makes their decision? What happens, when they hand down their decision? What are the next steps in that? What carries over to that finality when it means that that's it, the case is over and it's time to leave?
Yeah, typically, to get to trial, it's gonna take a little time sometimes to get scheduled. You might have to sit around for a few hours, you might have to come back another day. The court needs to find a slot for you. Most non-payment cases are not terribly complicated. The last one I tried, I don't think it took an hour.
Oh wow.
Once we
Okay.
finally could get heard, I mean, what you need is, you need to have a witness. You need to have a landlord. You need to have not just any person who, you don't want the guy who shovels the walk for the landlord. You want the guy who keeps track of the rent for the landlord.
Right.
Somebody who knows what they're talking about,
Right.
who can say, look, I keep the books, and John Smith here has paid the rent through October, but he's not paid November, December. And typically you want that written down.
Right.
It's not absolutely required that you do, but I think it makes your case stronger and there's less room.
That gold standard you talked about.
Yeah,
Right?
I think things a gold standard. You want to keep a rent roll. So if you've got something to refer to and you can bring to court to show that you're serious about what you're doing,
Absolutely.
it makes your testimony more credible. So the landlord can testify and on non-payment, and again, that's not a lot of that doesn't take a lot of time to do. It is like what you see on TV in a way. It's
Mhm.
pretty simple, pretty fairly quick.
Mhm.
In a non-payment case, that's about all you need to do, and then the tenant will have the chance to testify in the tenant's defense. And in a non-payment case, it's usually limited to either I paid or I didn't.
Right.
which makes the whole thing fairly quick
Mhm.
because they either paid or they didn't. Maybe have a swearing contest about whether cash was handed or it wasn't,
Okay.
which again, before you get to court, if you have a situation where you're taking cash, document it. Not only document it, but even write a letter periodically if you're taking cash that says, I received blah, blah, blah in cash,
Mhm.
and that's it. And if you see anything wrong, let me know. If you haven't been paid, maybe it's not a bad idea to write a letter and say, look, I've not received any cash.
I see.
If for some reason I'm misunderstanding something, misremembering something, then get back to me right away. Because if you get into a case of you know, a swearing contest of one person's word against another, it's not a great situation to be in.
Right.
Because you just really never know how that's going to come down. So communication, documenting things is, and even providing copies to the tenant. So you say, look, let's just so we all agree on the facts. These are my facts. This is all I got,
Right.
and I didn't get XYZ dollars, and that may be of some benefit to you by the time you get to a non-payment trial. But typically, a non-payment trial is not real complicated. They could raise this issue of Marini of habitability. They get there, again, if they paid rent into court, the court might even give them additional time to come up with a rent, put it into court, and then finish the trial. That's not
I
impossible.
got you. Yeah.
In my case, it was, I don't think the court gave me, I don't know, 10 days or something, maybe a week.
I see.
It can be whatever the judge thinks is reasonable. And typically the judge will rule at that point, and then you can apply for your order for eviction pretty quickly after that, just within a few days. And after trial, you're typically looking at a lockout through a constable or sheriff's officer. Um, and there's a couple of simple papers to file to do that. You also can file to do this process if you have a consent order, a settlement, which we spoke about before, which has been violated.
Okay.
And that's very simple to do. Either a consent order has been violated, or the judge issues an order for possession in favor of the landlord. Then you go to the process, making the application to the simple application to the court officer to do the lockout, pay him the money for new locks. I don't know, their fees are usually less than $100.
Sure.
And at that point, what often happens is the tenant will say, well, look, after the judgment, it's only been 10 days, 2 weeks, and I'm just not ready to go because, either I can't find a place or the dog ate my homework, whatever it is.
Yeah.
And typically they're going to get a week, maybe a week and a half.
So you're referring to just for our audience's understanding. So you go to trial and your client, you win on behalf of your client. Your client gets that judgment from the judge that says they get possession of the property back. And just referring back to what you had mentioned at the top of our class, you had said that it sounds like the remedies are bifurcated, like that in this court, this landlord-tenant court is just strictly for possession of the property.
Correct. You do not get an award of money.
Okay. But I mean, non-payment of rent, if you paid the money, would certainly make the case go away. But they're not asking for the court for that money.
That's right. The judge will say, look, this is the amount that's owed.
I see.
If that amount is paid, they get to stay.
Right. But if they don't and they lose their case, the judge says, landlord, you get the property back.
Right.
And that is like an affidavit, and that can be taken to the clerk's office, and they can, and from there, as you mentioned, simple paperwork, maybe simple for you, but probably best to have an attorney file on your behalf. And you bring that to the clerk's office, and then you're able to. Is there a certain period of time they have to wait from when the judgment comes down from the judge to when they have to apply?
I think it's 3 days.
Okay, so they get 3 days.
3 days. And those forms are available online on the court website, but that website is not real. It's not great for it. In theory, it's searchable, but it's not great.
Yeah. Yeah, it's certainly if you're not, experienced like as a practitioner like yourself, identifying the applicable forms and navigating, it's yeah, like you're right, I mean, just having guidance and having advice would be helpful in that
It would
regard
be
for sure.
helpful. You can
Yeah,
also get a package from legal services, which I don't think is terribly expensive.
sure.
I think they even have forms available.
That's great. That's great to know.
It's good. It's a good little manual.
Yeah.
Another source you can use is and DCA, Department of Community Affairs. They've got a couple of little guides, not as extensive as legal services, but they'll summarize the Anti-Eviction Act and
Okay.
what you need to do under the Anti-Eviction.
Because that sounds incredibly helpful too, because as you mentioned, the Anti-Eviction Act, it's complicated, it's complex stuff. And like, if you're not well versed in the legalese and you understand the terminology and the procedure that goes along with it, that could be incredibly difficult and overwhelming to navigate. And if you have a situation where you need to get paid, or you need to get possession of the property back, it's certainly helpful to have these resources, but even certainly better to have an expert like yourself to help navigate through that process. But it seems to be that the most important thing that we've talked about is certainly that communication early on. Would you say that it's better? And I know we said that sometimes, and that observation we had made that sometimes it's better to just rip the band-aid and just go to court and have that done. But even with the court process, do you think that it's often better and more favorable to both parties to settle as opposed to going to trial?
If it's possible, particularly with a consent order. I mean, I, I, I mean, if the tenant's being reasonable, working for the landlord, yeah. I mean, I always would rather have a consent order,
Sure.
um, because it's just simpler.
Right.
It's less time in court.
Hmm.
Um, the landlord doesn't have to testify, which for a lot of people, they don't want to testify.
Right. Yeah. Of course. That's a nerve-wracking experience.
Yeah, there are things that you can do without a lawyer fairly well, like Judge Judy. You know,
Yeah, sure.
I mean, you get in
Yeah.
front of
That's a
Judge,
great example.
you get in
Yeah.
front of Judge Judy, you just tell your story,
Yeah. Yeah.
and and Judge Judy's going to decide what's fair and what isn't fair based upon the two stories. The landlord-tenant court is not that, because landlord-tenant court is technical.
Yeah.
In other words, there's forms, there's technical procedures that are easy. They're easy to not get right.
Yeah.
Notice to cease, notice to quit, some of the landlord registration stuff and setting that stuff up and understanding it. Um, things like the Marini hearing. I mean, there's some technical issues there, which I think most people would benefit from getting some direction on, quite frankly.
Absolutely. Absolutely. I agree 100%.
Because
100%.
because what you lose is that if you bet wrong and you don't do it right, you know, you've lost 2, 3 months,
Mm,
and that could be a few $1,000s.
for sure. For sure.
So
Absolutely.
yeah,
It's worth investing in an expert and
sure.
getting that counsel. And like you said, and it sounds like even though you have that affidavit and then the warrant of removal, um, tenants can exercise their last attempt to stay on the property with what you call it's an order. It's
For orderly removal.
That's it. It's always it's a tongue twister for me. So
Yeah, yeah.
order for orderly removal is kind of like their last attempt to stay on the property,
Sure.
because they're unable to find suitable housing accommodations within the time, or they need to get their things together, or maybe they're working with Family Promise and they just need a little bit more time. I've also seen something called an order to show cause. What's the difference between the two?
Um, Order to show cause, it's sort of in many ways the same thing on different pieces of paper.
Oh, wow. Okay.
I mean, as a general proposition, in order to show cause is pretty much any application to the court, which you sort of do on a short notice.
Mhm.
You know, a lot of what is done in court has got specific time periods, like a motion. You can make a formal motion on a case, it's 18 days ahead,
Okay.
and you get to file by a specific filing date to get your motion hearing date. Order to show cause is, look, Judge, I got a bad problem. If we don't fix it, it's gonna be really horrible.
I got you.
And, an award of dollars isn't gonna solve my issue, and I'll be homeless, or whatever it is. So you can make that application on a couple days' notice, and court used to accept those fairly frequently. Um, and then I'd have to have a look at it,
I see.
and then I'd oppose it. And, I guess probably more often than I should have, I'm gonna write a fairly long opposition to say, look, they haven't paid a dime. They shouldn't be allowed to stay because they're not paying. If they want to stay, they should put up some money.
Okay.
I mean, for some purposes, they do have to do that if they want to stay. There's a statute about, people may say, look, I need to be here 3 months, I'm sick or having a baby or whatever it is. And typically they've got to pay to do that.
Okay.
But that's fairly unusual. And the normal way now to address that very brief period of a couple extra days is this application for an orderly removal.
Okay.
And, the way it's done now, they don't even give the landlords an opportunity to respond. They typically entertain it, and, you get an order before you really can even answer it.
That's interesting you say that because I've helped. I don't fill it out because I'm not an attorney. I can't do it unilaterally. I bring the clients there, and the clerk's office will help them with it in those cases where they need a little extra time, or we're trying to figure out where we're going to find funding to keep them in the residence.
Yeah.
But it will say there, like, it'll give you options how to put the landlord and their counsel on notice. Like, you can send it in the mail to their counsel that you've applied for an order for orderly removal, or you filed for an order to show cause. But often the judge, or the order from the judge, comes before it even arrives in the mail to the attorney's office.
Yeah,
So that's an interesting point.
Well, typically they're filing it electronically, and the lawyer's going to get a notice fairly immediately
Mhm.
through email
Oh, I see. Yeah.
of the
Okay.
filing, which is sort of the new way things are done.
Right.
So you'll see it, but even with that, you'll often get an order before you have any chance to respond,
Gotcha.
because the judge doesn't want to read it. I'm sure he doesn't want to hear from me, because those extensions are granted fairly routinely.
Yeah.
Brief periods of time.
Seems like it.
A week and a half, something
Yeah.
like that.
Okay. So, and then finally, just as we close out here, it sounds with if let's say including exhausting all options like the order for orderly removal, what's the typical time period from when the landlord gets their JOP, they go and they apply for the warrant of removal, from that application? When what's the time frame when a tenant is typically removed from the property after that?
About 2 weeks.
2 weeks. 2 weeks. Okay.
Maybe a little longer.
Okay.
It's not long. One thing you do have to watch is that when you get into the holidays,
Mhm.
those court officers, they are not working. They're taking Christmas vacation off.
Sure. Yeah.
Plus, they don't want to throw anybody out in the holidays
Yeah.
anyway.
Yeah.
Um, so sometimes what messes you up is holidays in terms of how quickly it gets done.
Sure. Sure. Yeah. And is there a way? So let's say the tenant has a lockout date, and that lockout date comes, and they are physically removed from the property, um, and the locks are changed. Is it final at that time? Can their tenancy still be restored after that? Is there a chance to get back into that house let's say they come up with the money somehow, and it's a non-payment of rent case. It's not like for, any other anti-eviction act violation. It's just non-payment of rent. Is there a way they can actually get back in and restore their tenancy even after that lockout date?
Well, I went to Cornell University
Mhm.
and I learned something very important. When you don't know, you say, I don't know. I don't think so. I think at that point, once the lockout has taken place, I think that's it.
Mhm.
Um, it's all really theoretical. I had a case who actually, guy took an appeal after being locked out
Mhm.
while he was in jail, which is why I took the appeal because he needed something to do, I guess.
Yeah. Yeah.
And I just would say, why are we doing this? What's he going to do? He's been locked out. We've made all these changes, bringing somebody else in.
Right.
What's
Right.
what's there to win?
Right.
He's done. He's out.
Yeah.
So I don't know how they would put somebody back in. I suppose there might be a circumstance, but I think it's unlikely.
Yeah. That's well, and I certainly appreciate that. So again, tonight's class was information, making information available to landlords. Mr. Wallace's experience and his background and what he does in his practice. Although it seems that he does a lot of different areas of property law, tenancy being one of them. It seems that what he does is he works with landlords, and we hope that tonight's information and has been really in depth and really again very thoughtful and considerate. Really considerate. We greatly are so grateful for the time that you've been able to devote to this. It's been really wonderful. It's been tremendously helpful and informational for anybody who has a chance to look at it. And I think it's not just helpful for landlords tonight as well. This information can go both ways. It can be helpful for anybody who comes across it. So, as we've been going through this course, from our first course in housing discrimination to familiarizing yourself with the law, to rent increases, to habitability, to terminating your lease, and now the eviction process as experienced by a landlord, it's really interesting to see the other side of the law and what's contemplated, the process that goes into it, the thoughts that go into it, the law that's applied, what's available out there, the remedies that are there, and what the experience is going to be like is really certainly helpful for everybody to understand and know as they go forward. But I think one of the most important things too is that we talked about, I think, is communication. Definitely often and early, communicating between the parties and getting representation if you can and getting it early. And that applies not only to landlords, but I want to make a point to the tenants as well, because Legal Services of New Jersey, I don't think it's the case right now. I've heard there's been talks about it, but as of right now, there is no constitutional guarantee attached to civil trials. So the constitutional right to attorney that you get in a criminal trial, you certainly do not get in tenancy court. So landlord, legal services, there's no guarantee that you will get representation, and you certainly will not get it if you're there the day of trial running up to them. It's going to be very difficult for them to give you that comprehensive legal counsel and representation that late in the game. So again, early is often, and it's not meant to be contentious. It's not meant to be adversarial. What it's meant to be is to protect your legal rights and honor and observe those legal rights. And so that you can come to the table with somebody who is well versed in the law, and you can go to the table and negotiate, because it sounds like settling is a really great option to do if it can be done and it's fair and realistic to the parties as well. So that seems to be a really great through line that was communicated tonight, and it's been communicated across all these classes: communication, early intervention, legal representation, and doing everything you can to communicate and abide by what's in front of you. So again, Mr. Wallace, I want to thank you for your time. Really appreciate.
Thanks for having me.
Really, thank you for the information. It was excellent. I really had a great time enjoying it. I hope everybody that views this has a really wonderful time, and it's been informational and helpful to you. Mr. Wallace is a practitioner in Montague, and was really just what an impact on our class tonight. Super enjoyed it, and thank you again for sticking around. And again, wow, thanks a lot. So another great evening with STEPP, Stabilizing Tenancy Eviction Prevention Program. I hope you all enjoyed it as much as we enjoyed presenting the material. Thank you again to Mr. Wallace. Thank you to the New Jersey State Bar Foundation. And we'll see you next time. So thanks a lot, and good night.
Awesome.
All right. Thank you so much.